So welcome to our seminar on recent developments in housing allocation. We've got two genuinely brilliant speakers tonight. We've got Liz Davies, Queen's Counsel, which is the first time I've said those four words out loud. It's quite exciting just to say that. And we've also got Tessa Buchanan. Now, I'm sure most, if not all of you, are very familiar with Liz and Tessa and their work, but just to give the obligatory introduction, Tessa has spent a large part of the last few years working assiduously to challenge the invidious widespread practice of no DSS, whereby private landlords refuse to rent to private sector tenants who are in receipt of benefits. I think there's no greater marker of her success, her continued success, together with Rosanna from Shelter in this area, then we now have a government white paper published on the 16th of June, which is promising to make illegal no DSS. And although Tessa will be modest and self-effacing about it, I have little doubt that that is a direct result of hers work and Shelter's work in that area. Liz, for her part, represents the intervener, HILPA, in the successful appeal in Khan and Mahmood, which confirmed that the Simmons and Castle 10% uplift does apply in disrepair cases. So to be perfectly clear, these are things that Liz and Tessa have achieved in the last week alone. I'm not going to go into the more distant past. So if I compare that to the things that I've achieved in the last week, I'll be honest, I don't come out of it looking great. It's involved eBay rather more than it has the Court of Appeal. But that, I think, will tell you why Liz and Tessa are the speakers tonight, and I am just the chair. Liz, Tessa and I, together with His Honour Judge Luba, Queen's Counsel, write a book on housing allocation and homelessness, which Liz is waving at the screen now, as I'm too ill prepared to have my own copy to wave at you. It's a pretty good book. It's no Harry Potter, but it is considerably more useful when it comes to assessing the legality of housing allocation schemes. I would say I'm generally a bit shy to plug the book because it feels a bit self-indulgent, which I suppose is a marker of why I'm not in marketing, but it is genuinely really good on the subjects we are going to be dealing with tonight. Chapters 3 and 4 of the book in particular are really good on issues such as discrimination, qualifying criteria, which Liz and Tessa will be touching on tonight, and there is a 20% discount, which I hope that David, our marketing guru, will be placing in the chat at some point during the webinar if you haven't got the book and you are interested in it. The book, for its treatment of the subjects we'll be dealing with tonight, is definitely worth a look at, because what Liz and Tessa are going to be taking you through are some not just recent developments, but some, I think, really quite difficult concepts in the area of the allocation of social housing. Questions like, when can you exclude a group of people from a housing allocation scheme? When is it lawful to say that one group of people can be treated more favourably or less favourably than another group under an allocation scheme? Questions like that can be simply expressed, but to answer them is really quite tricky, and some of the legal concepts involved in answering them are not settled and are subject to ongoing debate in the higher courts. So Liz and Tessa will be helping you navigate these rather tricky waters tonight. Questions will be saved to the end. There is a Q&A function, so please enter your questions at any point you want in the Q&A function. If you enter them in the chat, there is a reasonable chance I will miss them. If you put them in the Q&A, we'll definitely try and get to them, and we will deal with those at the end. So without further ado, I will hand over to Tessa.
Great, thank you so much, Connor. I'm just going to share my screen. Right, so hopefully you can now all see a slide with the Garden Court bay tree there. So as Connor's mentioned, we are talking today about recent developments in the law of housing allocation. I'm going to be looking at 3 distinct issues. Firstly, when can somebody who's entitled to reasonable preference be disqualified from the scheme? Also, are private registered providers public bodies for the purposes of allocating accommodation, and the position of applicants in overcrowded accommodation. But I'm going to start by a brief look at the legal framework behind allocation, because I think it's something that people don't necessarily deal with on a day-to-day basis, although obviously it is the end goal for so many of our clients to obtain settled accommodation in the social housing sector. So the starting point is, of course, Part 6 of the Housing Act, and that is accompanied by 5 codes of statutory guidance. In terms of legislation and policy, that is to say national policy, that's really it to a large extent. I mean, there are definitely regulations on specific areas, and I'll be touching on some of those, but those are the main tools in your toolkit when it comes to dealing with a housing allocation case. But in fact, that just places more importance on the actual scheme that you are considering, the local housing authority in question scheme, which is going to be the document which is central to any allocation case that you may be involved with. So what actually is an allocation? Well, it's defined at section 1592 of the Housing Act 1996 as occurring when a local housing authority select a person to be a secure introductory tenant of their own housing accommodation, or nominate someone to be a secure or introductory or assured tenant of housing accommodation, either held by them or held by a private registered provider or registered social landlord, more colloquially known as housing associations. It is a term of art, so it's not the case that any time somebody becomes a social housing tenant, an allocation will have taken place. And in fact, there are certain situations where even though somebody becomes a new social housing tenant, there won't have been an allocation for the purposes of Part 6, and so the rules under Part 6 won't apply to them. There's a fairly long list, and I've set out some, I tried to summarise some examples on the slide there. A common factor is that generally these exceptions to allocations exist when there's some sort of previously existing tenancy, whether that's by way of a tenancy which is passing by succession or to a potential successor, or an order transferring a tenancy in family law proceedings. A particular point to note is in relation to existing tenants. When a secure tenant is being transferred at the initiation of the landlord, i.e. at the instigation of the whole of the landlord, then that won't be an allocation, and it won't therefore be dealt with under Part 6. In terms of the situation which is probably more common, of a transfer which is initiated by the tenant, then it is an allocation if the tenant is a secure or introductory tenant or an assured tenant of a private registered provider. The allocation involves a transfer, the application for the transfer has been made by the tenant, i.e. it's tenant initiated. And most importantly, the housing authority is satisfied that the tenant is to be given a reasonable preference. And I'll come on to reasonable preference. In reality, most tenant initiated transfers probably will be allocations because they probably will be entitled to a reasonable preference. But if for some reason they don't, then it won't count as an allocation. There are 3 hurdles to getting an allocation. I've put 2 of them on the screen. Firstly, eligibility, which is a question primarily of immigration status or residence status. It's very complex and I won't be going into it in the seminar. I think you'll all be relieved to know. I certainly am relieved not to be covering it. The second is qualification, which I will come to again under the question of reasonable preference. But in short, a local housing authority can develop its own criteria for specifying who does or does not qualify for an allocation of housing accommodation. And then the third hurdle is simply realpolitik. It's the fact that there is a serious shortage of housing. And so even if you're eligible, even if you qualify, even if you're entitled to a reasonable preference, you may not get an allocation for years, you may never get one. And that's something which I think all of you will be used to drumming home to your clients at the beginning of a case, that ultimately there is often only so much that can be done with allocation cases because the background is there isn't enough social housing. So all local housing authorities must have a scheme. That scheme must set out how they'll determine priorities and what procedure will be followed, including things like who's going to take the decisions as to who will be made an allocation. And the scheme must give reasonable preference to 5 categories of people. Those are set out as section 166A3, and they're essentially people in housing need. So people who are homeless as defined by Part 7, people who are owed particular housing duties, people occupying housing which is in some way unsatisfactory, or people who need to move either on medical or welfare grounds or to avoid hardship. In addition to this Part 6 sets out that the scheme may give additional preference to somebody who has reasonable preference and urgent housing needs, and that it must give additional preference to somebody who has reasonable preference and has urgent housing needs and is, and I'm summarising here, a veteran or a disabled member or widow or widower of somebody in the armed forces. And the scheme may also set out how the priorities amongst people entitled to reasonable preference will be determined. And in reality, the scheme will almost certainly do that and may well be challengeable on the grounds of uncertainty if it doesn't, because the groups of people entitled to reasonable preference are so large generally that if we don't know how they're going to decide between those groups, you may not have a very meaningful scheme. Then finally, there are certain rights of notification. Some of these come from the statute itself. So Part 6 says that local housing authorities must notify applicants that they're not eligible, if that's their decision, or that they don't qualify. And then in addition, they must frame their scheme so as to ensure that applicants have the right to be notified of decisions about a quite wide range of matters, including the fact of their case, certain review decisions, as well as general information about how their application is likely to be treated. And in addition to that, the scheme has to be framed so as to ensure that the applicants have the right to request a review of various decisions, including any decision about the fact of their case and also ineligibility and if they don't qualify. So that is a whistle-stop tour through Part 6 of the Housing Act and the framework for allocating social housing. Just a few sort of practical points, as it were, about bringing an allocation case. The starting point is always going to be to obtain a copy of the housing allocation scheme that your client is seeking accommodation under. These days, it's usually on the website of the local authority. If it's not, then there is a statutory right to request it under section 1682 of the Housing Act. Once you have the scheme, your first question will be to look at whether your client's application has been decided in accordance with the scheme. So has the scheme actually been applied properly to them? Have they been given the points to which they are entitled because of their factual circumstances? Has a particular policy which might benefit them been considered in their case? And then if it has, or in any event, the next question is to ask whether the scheme is lawful. And often it's tempting to jump to that and to say, well, the scheme is discriminatory, or there's some underlying problem with the scheme, and maybe there is. But the starting point is usually to look at whether your client's application has actually been determined in accordance with the scheme. And if it hasn't, then that may well give you grounds for, firstly, a review if you are able to request one, and secondly, potentially an application for judicial review. So turning to the first of the substantive topics that I want to look at today, this is the somewhat vexed question of reasonable preference and qualifying criteria, because these are two measures, both of which are provided for in Part 6, but which between which there is a clear tension. And that's a tension which has been explored in a number of cases today and arguably hasn't yet been satisfactorily resolved, although there is a recent decision on it, which I will come to. But the starting point is reasonable preference, which I alluded to above, and is essentially the requirement under section 166A3 that the scheme must be framed so as to secure that reasonable preference is given to those 5 groups of people. Just to point out a slight anomaly, obviously, in section 166A3B, we no longer have section 1923, that was repealed, and in addition we have provision for reasonable preference to be given to people owed the prevention but not the relief duty, but in summary that is a category for people owed duties under Part 7 of the Housing Act, so people owed certain homelessness duties. So on the one hand, therefore, the scheme has to give reasonable preference to those groups of people, and the question as to what is reasonable preference is an interesting one and possibly a seminar in its own right, but the courts have been fairly sort of clear in emphasising that it doesn't mean absolute or overwhelming preference, and it certainly doesn't mean that somebody in one of these groups will be guaranteed an allocation of social housing, but they must be given some preference within the scheme. But then on the other hand, we have section 160ZA, which says that a local housing authority can designate certain classes as either qualifying or not qualifying for allocation under their scheme. So a person may be allocated housing accommodation by a local housing authority if they are a qualifying person, or if they are one of two or more people applying jointly and one of them is a qualifying person. And subsection 7, the local authority is the body that decides what classes of person are or are not qualifying people. So it's a broad discretion, but it's not an unlimited one. And there are limits from statute and elsewhere on this power to qualify and, more importantly, to disqualify. Firstly, there are 2 express restrictions in section 1ZA. The first of those is that a local housing authority can't allocate to someone who's ineligible. So you can't have a qualifying class of sort of defined by reference to ineligibility. And even if someone who's ineligible would fall under another qualifying criterion, they can't be allocated social housing. And then secondly, the qualifying power, or the power to set qualifying classes, is subject to regulations made by the Secretary of State. And we have 2 sets of regulations which have been made to that end: the qualification criteria for armed forces and the qualification criteria for the right to move, both of which essentially provide that certain classes, you can probably guess the target of those classes from the title of the regulations, can't be disqualified on the grounds of local connection. And in addition to that, we have other limitations. So it's a fairly basic point, but obviously the qualifying criteria have to be lawful in themselves. And you might think that's a sort of fairly easy hurdle to overcome, but it means, amongst other things, that they can't be unlawfully discriminatory. That's something that Liz will be talking about, but we have seen a number of challenges, some successful, some unsuccessful, saying this qualifying criteria is unlawful because it's discriminatory, or perhaps breaches the, doesn't take into account the public sector equality duty. And in addition to that, it does seem now to be settled that the local housing authority has to retain an overarching discretion to make provision for exceptional cases. This was in some doubt for a while because of a case from, I think, 2016, possibly 2015, called Hilton and Epping, when the High Court sort of indicated that that wasn't necessary. But since then, we've had the case of Hillingdon and Holly, in which the Court of Appeal made clear that there should be a discretion retained within the scheme. But then that raises the question, can local housing authorities disqualify people who are entitled to a reasonable preference? So how do those 2 provisions marry up? And the starting point, or a good starting point, is what the government said when they brought in this power to disqualify. And in a consultation document from November 2010, it was stated by the then coalition government that we want to provide local authorities with the power to decide who should qualify to be considered for social housing, while retaining a role for government in determining which groups should have priority for social housing through the statutory reasonable preference requirements. And it's important that those who are vulnerable and in housing need do not lose out under these changes, and that they continue to be in the frame for social housing. We believe that the statutory duty on local authorities to frame their allocation scheme to give reasonable preference to certain groups, together with their wider equalities duties, should serve to ensure that local authorities put in place allocation schemes which are fair, and that those who are vulnerable and in housing need are properly protected. But that admittedly does not deal head on with the question, but it does certainly seem to indicate that the reasonable preference categories are a baseline, that the qualifying criteria shouldn't cut through those and exclude people who are in housing need, which is obviously what the reasonable preference categories are all about. But then we got the guidance in 2012, and this is a mixed bag in itself. It states at paragraph 3.26 that in framing their qualification criteria, authorities will need to have regard to their duties under the equalities legislation, as well as the requirement in section 166A3 to give overall priority for an allocation to people in the reasonable preference categories. And then in the next paragraph, housing authorities should avoid setting criteria which disqualify groups of people whose members are likely to be accorded reasonable preference for social housing, for example, on medical or welfare grounds. However, authorities may wish to adopt criteria which would disqualify individuals who satisfy the reasonable preference requirements. This could be the case, for example, if applicants are disqualified on a ground of antisocial behaviour. So, I mean, this does say that authorities might want to adopt criteria which would disqualify individuals who satisfy the reasonable preference requirement. So that does seem to be a nod in favour of qualification criteria being able to exclude those entitled to reasonable preference. But it's couched in the context of avoiding setting criteria which disqualify groups who are entitled to reasonable preference. And we'll need to have regard to the duty to give reasonable preference. So it doesn't really clarify the situation much further. And therefore, not surprisingly, we've seen a series of cases on this issue. I'm going to start with Wolverhampton and Watters. This isn't a case exactly on qualification and reasonable preference, not least because it predates the power to set qualification criteria, and I think in fact actually predated the Housing Act 1996 itself. But in that case, the claimant had been refused admission onto the waiting list because she was in rent arrears, and the Court of Appeal said that that was lawful because she was entitled to reasonable preference but not absolute preference, and that envisaged that other factors could weigh against and so diminish and even nullify the preference. So really that's a case about reasonable preference and what that means and what an applicant entitled to such preference should be given. But at the same time, on the facts, this was a person who was entitled to reasonable preference who wasn't allowed onto the register, and the Court of Appeal said that that was fine, that was lawful. So it's a case that weighs in favour of and has been found to support the conclusion that qualification criteria can exclude people entitled to reasonable preference. Then we get into the cases which do grapple with the issue more directly. The starting point and one of the most important is the case of Chikima Vashuti and Hammersmith and Fulham. And I apologise if I pronounced that wrong. But this was a scheme which disqualified applicants who had been provided with suitable temporary accommodation under Part 7. And I put the headnote there because it's a useful summary and seems to sort of very clearly indicate that qualification criteria can't be used to exclude people with reasonable preference. So the summary there is that an authority's duty under section 166A(3) of the Housing Act to frame their allocation scheme so as to secure that reasonable preference is given to certain classes of people is a fundamental requirement which applies to the arrangements of allocation as a whole, including the setting of any qualification criteria under section 160ZA(7). And then in the judgment itself, paragraph 31, the reasonable preference duty applies on its face to the framing of the scheme as a whole, and so as to require the giving of reasonable preference to all those specified, not just to those who are qualifying persons. There's no sensible reason why it should be read as applying only at the stage when the qualification criteria have operated to exclude certain applicants, and thus on the natural interpretation of statutory provisions, the setting of the qualification criteria is subject to the reasonable preference duty. So you might think that that answers it, but it hasn't, or at least it hasn't been treated as answering it. Part of the reason for that, I think, is a comment that was made at paragraph 45 of the judgment, where it was observed it is permissible to adopt a rule excluding individual applicants by reference to factors of general application, such as the lack of local connection or being in rent arrears, but it's not permissible to cut down the statutory class in the way that the scheme in that case attempts to do. There's a question mark, at least to my mind, over that paragraph, because although it's been relied upon in subsequent cases to support the conclusion that qualification criteria can exclude people owed reasonable preference, in context, my view, for what it's worth, is that that seems to be more the Court of Appeal reciting the arguments that were made to the court rather than express finding from them. But it's something that in any event has been relied on subsequently. We then got a number of cases which differed in their results, but broadly, I would say, were in favour of the qualification criteria not being able to exclude people with reasonable preference. So we had H.A. and Ealing, which is a well-known case, and it's more to do with other issues, including discrimination, but it was a ground in that case that the application process, which had automatically rejected the claimant, was unlawful because she was entitled to a reasonable preference, and it had effectively denied her that. And the judge found that although a residency requirement was entirely appropriate and indeed encouraged, it couldn't preclude or exclude the class of people who fulfill the reasonable preference criteria. Although it's fair, I think, to note that this was a fairly short passage in the judgment, and that the claim was certainly allowed on other grounds as well. We then have two cases which I think are quite difficult to square with each other. We have firstly the case of Eleni and Westminster City Council, which was a scheme which prevented an applicant who was owed the main housing duty from bidding for 12 months. That was held to be unlawful on the basis that the scheme carved out a subgroup which was altogether excluded from the potential of being allocated social housing for 12 months. They have no preference, and the Act doesn't permit the removal of a whole subgroup from a group which is required to be given reasonable preference, when that subgroup is not defined by reference to differentiating features related to the allocation of social housing, but applies a simple time bar. So it's somewhat equivocal, although the result in that case was that the reasonable preference duty was not being observed. There is clearly an acknowledgement that if it was defined by other references, i.e. differentiating features related to the allocation of social housing, then the result might be different. And then we have the case of Wolf, where people with fewer than 120 points were prevented from bidding. And in that case, that was lawful, even though the claimant fell under that threshold and therefore wasn't able to bid on the grounds that the bidding threshold was not concerned with preference, but was about managing the bidding process. One further case to mention before I get on to Montero is Ward. This was a case which is a really interesting one for lots of different reasons. It's mainly a discrimination, public sector equality duty case, but there was a sort of tantalising comment by, I think, Lord Justice Lewison, where he stated that all eligible persons included in the reasonable preference groups must be treated as qualifying for inclusion in the allocation policy. That was obiter. And wasn't part of the ratio of that decision, but is nevertheless instructive. And then we get to Montero, and this is the recent case where the court found that it was lawful to adopt a qualifying criterion, in that case, local residence, on the grounds that, or local connection, on the grounds, even though it excluded the claimant who was entitled to a reasonable preference. And the court found essentially that there was a distinction between a class which tried to thwart the statutory scheme and a rule which excluded individual applicants by reference to the factors of general application. That's the phrase from Joachim Vashuti, which I referred to earlier. And that whilst in the earlier case, the criterion had fundamentally undercut the statutory purpose, a use of criterion based on residence didn't do that, wasn't fundamentally at odds with the purpose of the provisions. And it was also observed that there was some encouragement for such classes in the codes, and that if such a criterion couldn't be applied to people with a reasonable preference, then there'd be little scope for the practical operation of such a requirement, although I would be inclined to think that's more an indictment of the housing situation and the shortage of housing than perhaps a principled reason for finding such a criterion to be lawful. So where are we now? Well, I think there's uncertainty over where we are. We have two conflicting first instance decisions. We have HA and more recently Montero. We potentially have conflicting dicta from the Court of Appeal in terms of what was said in Joachim Vashuti about individuals being excluded by reference to factors of general application, and then obviously comments made by Lord Justice Lewison in Ward, although see my query as to whether or not Joachim Vashuti was in fact part of the argument or true obiter. It seems fairly clear that what a local authority can't do is disqualify a class of people by reference to the criterion which is actually what entitles them to a reasonable preference, such as being owed a particular homelessness duty, and you can't circumvent that by suspending them for an arbitrary period. Other than that, as matters stand, obviously the most recent decision is Montero, and it's fair to note that that was more thoroughly reasoned than the decision in HA when there were a number of other grounds. But I think it is difficult to reconcile these decisions, and obviously any challenge that's brought will need to address Montero, but it does seem to me that the clarification from the Court of Appeal would be welcome. Turning now to applicants in overcrowded accommodation. So as we've looked at, local authorities have to give reasonable preference to people occupying overcrowded housing. There isn't a definition in Part 6 as to what overcrowded housing is, and local authorities can therefore adopt their own definition. And I've suggested, or I put some possibilities on the slide local authorities may wish to or may be, decide to adopt. Perhaps the most common is the statutory definition in the Housing Act. So that should be HA 1985. And that's certainly what people generally mean when they talk about statutory overcrowding. We had a decision a few years ago on overcrowding when a local authority had given increased priority to overcrowded households in the social housing sector over households in the private rented sector. And a challenge that failed. It was found to be a measure which was in pursuit of a legitimate aim, that aim being to remove what was said to be an incentive on households in the private sector to stay in their overcrowded accommodation. And it was a proportionate means of achieving that aim. And also that it didn't contravene the requirement to give reasonable preference, because the preference given to the claimants group, even though it was just band C, was reasonable. But then we've more recently had two decisions, both concerning Southwark's allocation scheme. And in both cases, it was to do with the provision in the scheme under which band 1 priority was given to statutorily overcrowded applicants, but only if they hadn't caused the statutory overcrowding by a deliberate act. Now, in the first case, that of Flores, the claimant had moved into a 1-bed flat, which was all that he could afford at the time, with his partner and 2 children, who were very young at that point. But the flat then became statutorily overcrowded as the children grew older, and the local housing authority said that he'd caused his overcrowding by moving into the flat in circumstances where it was inevitable that it would become overcrowded as the children aged. And the Court of Appeal held that that decision wasn't lawful. They said firstly that deliberate, as in a deliberate act, doesn't necessarily involve culpability, which was a submission made on behalf of Mr. Flores, which was rejected. But they essentially found that it was artificial to say that the cause of the overcrowding was this Mr. Flores' decision several years before he even applied for housing to take a tenancy of the existing occupation, which had been the best that he could afford at the time. And indeed, there's a sort of quite telling rhetorical question asked at paragraph 44, which was, one might ask, what else was he do? And the court noted that the local authority's decision exceeded the bounds of any flexibility which might be given to them in how they implement the scheme, and could lead to some odd or even perverse consequences, such as an applicant who acts reasonably by taking accommodation, which is the most suitable that he can afford, thus disqualifying himself from an allocation. And then we had the decision in Roman and Southwark, and this was slightly different on its facts, because in that case, the accommodation had been statutorily overcrowded from the moment that the applicant moved into it, although the context was the same in that it was the best that the claimant could find at the time. And again, the authority decided that he'd caused the overcrowding by a deliberate act, and there were various factors relied on, so it wasn't reasonable for him to have moved into it. He'd given up accommodation elsewhere. He hadn't tried to find other accommodation or better his situation. And that claim was also allowed. Firstly, the local authority had not correctly interpreted what was meant by deliberate act. The correct interpretation was that an act is only deliberate if the applicant intended to do it, in the sense that they had a real choice between 2 or more viable options, and they voluntarily elected to do that act. And the reason for that comes from partly from the Court of Appeal's judgment in Flores, where they'd said that an act was deliberate if it's something which the person intends to do, but it also drew on homelessness cases and the rejection of the submission that somebody who chooses not to pay the rent in favour of feeding their children, where they can't afford to do both, is acting deliberately. That's something that the courts haven't kind of accepted as a submission, and it was a similar kind of reasoning here. And in addition to that, there were irrationalities in the way that the local housing authority had reached this decision on the case, and various sort of findings as to what the claimant could or should have done were rejected by the court. There were also 2 other grounds which were dismissed, most notable being an argument that the guidance given to housing officers as to how to implement the scheme wasn't something which required to be published. And it was notable that it wasn't inconsistent with the scheme. It just gave examples of conduct that may amount to a deliberate act, which is potentially of wider relevance, although obviously it's always going to be fact specific as to what document there is and what hasn't been published. And then finally, I'm just going to touch really briefly on this question because there was a recent case on it, which I just want to highlight. And it's on the question, which is another long-running query as to whether private registered providers are public bodies, specifically when they allocate accommodation. I'm sure everyone will have some familiarity with the case of Weaver and London and Quadrant, when it was held by the Court of Appeal that the housing association's function of allocating and managing housing was of a public nature. And the relevant factors which were cited in that case are ones that are useful to look at and to consider in any cases you have where it may be disputed that a housing association is a public body. They included facts like that the reliance on public finance, the close working with local housing authorities in pursuit of the local housing authority's own statutory duties and objectives, the fact that by providing subsidised housing, the housing association was providing a public service, and the intrusive, as it was called, regulation which the housing association was subject to, which was designed, at least in part, to achieve the objectives of government policy. So in that case, although it wasn't itself an allocation case, it was about a decision to terminate tenancy, it was found that the housing association was a public body amenable to judicial review and a public authority for the purposes of the Human Rights Act. Then after Weaver, we got a number of decisions, most of which were that the private registered provider or housing association was exercising public functions, and the factual scenarios range from refusing a mutual exchange, refusing to allocate a property, in how transfer applicants were to be prioritised. Although I would just flag up there was a case, McLeod and Peabody, when it was found that the Peabody wasn't exercising a public function when it refused to approve a mutual exchange. And then finally, we have this recent case of TRX and Network Homes, where Network Homes had refused an application by one of its tenants for management transfer to alternative accommodation under its allocations and lettings policy in situations where the claimant was in fear of her ex-partner having suffered from domestic violence. The defendant accepted that it might be treated as a public body, but said that it was acting as a private landlord in the management of its stock and in regard to internal transfers. And this was a submission which was rejected by the court. The court found that the decision to refuse the transfer and the allocation policy itself were amenable to judicial review, and that Network Homes had been exercising a public function for the purposes of both the Human Rights Act and the Equality Act. And relevant factors included the reliance placed in the allocation policy on the defendant working in partnership with local housing authorities. Also the fact that this was a huge social housing provider. They had some 20,000 homes across the southeast. The vast majority of its stock was social housing. They'd received an allocation of over £100 million to deliver 1,000 new affordable homes, and various other factors. And in light of the acceptance by Network Homes that the provision of social housing to the claimant in the first place was a public law function, and then it couldn't sensibly be said that the consideration and refusal of a transfer is other than part and parcel of determining the allocation of that housing. So it may not be that this argument that housing authorities, housing associations are not public bodies when allocating accommodation is yet dead in the water. There may still be life in it, but I think it's an increasingly difficult one for housing associations to run. The case law does, in my view, sort of overwhelmingly fall in favour of the private registered provider being a public body, and as was really acknowledged in the case of TRX, a housing association saying otherwise faces an uphill struggle. So I'm going to hand over now to Liz, who will talk to you about how public bodies must not discriminate. Thank you.
Right, can you hear me now? I'm hoping you can. Yes, Tessa is nodding, and I am just getting my slides up. So bear with me. I'm needing a little help because I can't move my slides on, and I'm not sure why that is. So I'm hoping that someone from Garden Court can come in and help me on that. Got it. Yes, moving on. Right. Sorry about that, my technological incompetence. Thank you, Tessa, for that. Thank you for helping us on starting off with how allocation works, because I think that's always incredibly important. What we often have is clients coming in saying, well, why haven't I been offered a property yet? And there's a lot to, that's the end they want, but there's an awful lot to get in order to get to that end. I'm going to deal with the discrimination side of it. And like Tessa, I've divided my talk into, in my case, two sections. The first section I'm going to deal with private law discrimination, direct, indirect, and disability discrimination and reasonable adjustments. And then secondly, I will go on to the public law functions of the public sector equality duty. I should say that all our references to the Housing Act are in relation to Part 6 as it applies to local housing authorities in England. Part 6, of course, does apply to local housing authorities in Wales, but different statutory provisions, and in particular qualification is quite different. So if there is anyone here from Wales, you will be alive to that, because you'll be alive to being treated differently, and you will amend what we say in relation to the sections that apply to Wales. So moving on, like Tessa, I'm going to start with a reminder of what the Equality Act actually says. And there are three important concepts. The first is direct discrimination, which is fairly obvious. A person discriminates against another if, because of a protected characteristic, A treats B less favourably than A treats or would treats others. In the context of allocation, it's rare that it comes up, but it does. I'm going to treat you to the case of Z that was in the Supreme Court, where there was an allegation of direct discrimination, but the sorts of less favourable treatment that would arise is if a local authority, heaven help us, decided that they were only going to let to men and not to women, or to certain nationalities, or to certain types of perhaps different sex partnerships rather than same-sex partnerships, all of which would be utterly shocking. But you will see in the case of Z that it has been argued. The much more common scenario that gets argued and is sometimes successful, we're going to look at it, is indirect discrimination, section 19 of the Equality Act. A person A discriminates against another B if A applies to B a provision, criteria, or practice, usually shortened to PCP, which is discriminatory in relation to a relevant protected characteristic of B, and it is discriminatory if A applies or would applies it to persons with whom B does not share the characteristic, and it puts B and persons with whom B shares that characteristic at a particular disadvantage compared with those who don't have that characteristic. It puts B at that disadvantage, and A cannot show it to be a proportionate means of achieving a legitimate aim. So you need a provision, criteria, or practice. You need a disadvantage to a group of people that is related to their protected characteristic, and they are to disadvantage compared with those who don't have that protected characteristic. But even where you have that disadvantage, it may not be discrimination. And it's not discrimination if it is a proportionate means of achieving a legitimate aim. And rather than speculate about what that might look like, then we will see it in a number of allocation cases that I'm going to talk about shortly. There is also disability discrimination. You can, of course, be subject to direct discrimination on the basis of your disability if you were told that a property isn't going to be let to you because it is not let to disabled people, or you can be subject to, there can be indirect discrimination on the basis of disability. But in addition, then there can be disability discrimination under section 15, where a person A discriminates against the disabled person, if A treats B unfavorably, so you have to have unfavorable treatment, and that is because of something arising in consequence of B's disability. So it is not a defence for A to say, well, I would treat everybody like that. If A, for example, refuses to install a ramp to get up the steps to a house and says, well, I would refuse to install a ramp, whoever was asking, then it doesn't matter that the person's asking is a wheelchair user, then they are still treating that B unfavourably because of something arising in consequence of B's disability. And then there is no justification. The burden shifts to A to show that the treatment would be a proportionate means of achieving a legitimate aim. And if A can't show that, it's disability discrimination, provided that A knew, either knew or reasonably should have been expected to know that B had the disability. What types of characteristics produce unlawful discrimination? It is perfectly lawful to discriminate against people on the basis of a number of things that are not in the Equality Act, for example, social and economic status. It is not lawful to discriminate against people on the basis of one of those 9 protected characteristics which are set out in the Equality Act. When you are looking at age, marriage and civil partnership, pregnancy and maternity in particular, then there are exceptions for various forms of direct and indirect discrimination and in relation to the PSED. So you always do need to double check that. With gender reassignment, race, religion or belief, sex and sexual orientation, then discrimination on that basis is unlawful. Within the Equality Act, in what circumstances might somebody unlawfully discriminate? And the reason I raise that, you'll see that when we get to the cases later on, is there's been some debate about whether an allocation of social housing falls under Part 3 of the Equality Act, which would be Section 29, or Part 4 of the Equality Act, which would be Section 33. The reason for that is that Part 3 deals with public services and provision of public services. Part 4 deals with the much broader issue of managing, letting, disposing of premises. So Part 4 clearly applies to the private rented sector, to private landlords, to lettings agents and so forth. And indeed, Tessa's Equality Act, no DSS Equality Act cases were brought under Part 4. The reason why it matters whether or not an allocation and a decision to grant somebody a secure tenancy or an introductory tenancy or an assured tenancy falls under Part 3 of the Equality Act or under Part 4 is when we get on to the reasonable adjustments duty. Because under Part 3 of the Equality Act, then a service provider has a proactive responsibility to consider reasonable adjustments for disabled people. Whereas under Part 4, Section 33, the management of premises, that reasonable adjustments duty only applies if the provider of the services, the person who's going to let the premises, is on notice of the need for reasonable adjustments. And that's quite an important point. But it has been answered, fortunately, by the administrative court. And then finally, the other form of discrimination that gets pleaded is under the European Convention. Who knows what's going to happen to the European Convention in the next few months, but anyway. Article 14 of the European Convention, the enjoyments of the rights and freedoms set forth in the Convention shall be secured without discrimination on any ground, such as, and then there are various characteristics set out. Some of those are in the Equality Act as protected characteristics, such as sex. So in a sense, Article 14 adds very little to a discrimination claim brought on the basis of sex under the Equality Act. But the important point is the last 2 words, other status, because that is the basis in which you can argue that there is unlawful discrimination, not on the basis of one of the protected characteristics in the Equality Act, and therefore not a breach of the Equality Act, not discrimination under the Equality Act, but discrimination under Article 14, if you can show that it was discrimination on the basis of other status. And I've given you 3 examples of what other status might be: being homeless, being a care leaver, and the case Tessa mentioned, being a private rented sector tenant. Obviously, the possibilities are boundless, as it were. So that allows you to bring in discrimination issues where you have a characteristic that isn't provided for in the Equality Act. But Article 14 is not freestanding. That's important. You can see it in the text. The enjoyment of the rights and freedoms set forth in the Convention shall be secured without discrimination. It does not say there shall be no discrimination. It says there shall be no discrimination in relation to the rights and freedoms in the Convention. So Article 14 has to be connected to the enjoyment of a right or freedom in the Convention. What right might that be in the case of allocation? One immediately thinks of Article 8, the right to respect for your home, and indeed the right to respect for your private and family life. That's not really been fully considered by the courts. It was assumed in the case we're going to look at in a minute called HA and Ealing. It was doubted by the Court of Appeal in 2 subsequent cases. The Supreme Court doubted the Court of Appeal's doubts in Z and Hackney, which we're going to look at. So it's slightly an open question, but clearly the starting point is that the Article 14 right to not to be discriminated against in relation to allocation must be within the ambit of Article 8. That must be the argument. Right. When are you going to consider discrimination issues, whether you're acting for somebody who is waiting for their waiting to go on trying to get onto the allocation scheme, waiting for one of their bids to be successful, or whether you're advising local authorities? You have to have the Equality Act and Article 14 in mind when local authorities are drawing up the allocation scheme. We're going to look at the public sector equality duty in the second half of my talk, and they also apply when the local authority is making decisions on separate allocation, on separate applications. And what sort of decisions might those be? They might be when the local authority is setting its qualification criteria. Those qualification criteria cannot be discriminatory. They might be when the local authority is looking in the allocation scheme at how it's going to give different priority to the different groups. Those entitled to reasonable preference, and maybe those who don't have a reasonable preference at all, but within the reasonable preference categories, and any other decisions that arise in relation to a decision on an allocation, such as what is the date of the application, how are you going to organise waiting time points, if there are sanctions in the allocation scheme, those mustn't be discriminatory, and similarly any decisions relating to being offered a property. So they arrive in the broad sense of the drawing up the allocation scheme, and then they arise in any decision that is being made on an application under the allocation scheme. Right, let's look at the case law. And we start with HA and Ealing, which Tessa talked about. Ms. HA had she'd applied to Ealing as homeless. She'd been successful. A homelessness duty had been accepted. She'd left another borough because of domestic abuse, and precisely for that reason, then she did not have 10 years residence in Ealing. As Tessa said, Ealing had the qualification criterion of 10 years residence in order to go on the allocation scheme at all. It was a qualification criteria, and she was held. It was held first of all that she, as a female victim of domestic violence, she had other status for the purposes of Article 14. Secondly, that Article 14 and Article 8, that an allocation scheme fell within the ambit of Article 8. Thirdly, that unsurprisingly, although it's always worth putting the figures in when you're arguing a discrimination claim, women are more likely to be subject to domestic abuse than men, and therefore there was a provision criteria or practice that disproportionately affected women. And so, having decided that there was a disproportionate effect on women who were fleeing domestic violence of having to show 10 years qualification, then the court asked Ealing what justification had been put forward for treating those women differently than other applications for social housing. An answer was there none. So the burden shifted to Ealing to show justification, and they couldn't do that. And that's an important point, because quite often, as we will see in the next case, where a local authority has thought about a potentially discriminatory provision properly, then they may be able to justify it. And that was the case with the Islington case. C, very similar to Ms. H.A. She'd left a different borough as a result of domestic violence, gone to Islington, been accepted as a homelessness duty. She was on the allocation scheme. There was no issue about qualification. So the issue was about the number of points she had. And there was a local letting scheme that gave priority to residents on existing estates where new homes were being built. And clearly she could not get that form of priority because she hadn't lived in Islington. She hadn't lived on any of those estates. And so there was, first of all, she fell within Article 14 as a result of other status. Secondly, clearly she was a woman, and so the Equality Act applied. She had a protected characteristic. There was different treatment between her on the one hand and residents on Islington's estate. So the question of justification arose. Islington had to justify it, but they were able to do that because when they had introduced their local lettings policy, it was intended, and indeed it had, a beneficial effect on the provision of social housing, and a fair and proportionate balance had been struck between the severities of consequence for C. Obviously, she didn't get as many points as the residents on the estate, but the importance of the aim of providing more social housing in the borough, and therefore benefiting local residents. And the same justification, whilst there had not been an equality impact assessment, which usually helps with public sector equality duty, that justification showed that the public sector equality duty had been complied with. In a sense, I could almost stop there, because my main point is that when there is no justification, when there is unfavourable treatment and there's no justification, then the local authority is in trouble. When there appears to be unfavourable treatment, but the local authority has thought about it properly, then a local authority may well be able to resist an indirect discrimination claim and or an Article 14 discrimination claim. But I'm not going to stop there, because I'm a lawyer and I like talking about these things. H and Ealing. Ealing won this. They lost in the administrative court, and then they won in the Court of Appeal. They had a local letting scheme reserving 15% of allocations to working households, 5% of allocations to model tenants seeking transfers. And the claimants were households who were all parents or carers of children, and they couldn't work, partly because they had disabilities, partly because of their caring responsibilities. The Working Household Priority Scheme could be indirectly discriminatory because disabled persons and the elderly were less likely to be in work than others, and therefore would not qualify for those 15% of an allocations. But when looked at in the round, then the Working Household Priority Scheme was justified because there was legitimate aim to encourage households into work, and it was only 15% of the allocations. When you looked overall at the allocation scheme, then protected groups who, as in these claimants' cases, couldn't work, were still in the scheme. They were banded according to the greatest need. There was discretion and so forth. The Article 8 point did not apply in relation to model tenants seeking transfers, because they were seeking transfers, so they already had a home. They were not homeless, and in any event, then any difference in treatment was justified. And then XC and Southwark is another scheme, another case where Southwark's scheme survived. They too had these incentives for working households, and community contributions, not by way of reserving a number of allocations, but by giving additional points, stars for points. The slide needs a site amendment. She wasn't a council tenant needing a transfer. She was in fact a homeless applicant in homeless accommodation. She was disabled and therefore couldn't work, so she wouldn't be entitled to the star for working household or for community contributions. Again, potentially indirect discrimination against her as a disabled person and also against women with childcare responsibilities. But overall, it was a legitimate aim to encourage work, to create sustainable, balanced communities, encourage residents to contribute to the local community. This was the least intrusive measure, and it was a fair balance. And then we come to really so that was the Court of Appeal. This was the second case in the Court of Appeal, which went the other way. And it went the other way because, frankly, Hillingdon hadn't thought about it. And also because the facts were much more shocking. Again, we have a 10-year residency requirement. Initially, it was a qualification criteria, just as in HA and Ealing. As a result of HA and Ealing, then Hillingdon amended the scheme, so it was no longer a qualification criteria, but it became relevant to priority. So if you didn't have 10 years, you were placed in Band D, which was the hopeless band, because there were bands A, B, and C who were all above you. In the case of Ward, it was 3 Irish travellers. They were travellers, so they didn't have 10-year residency. And in the case of Gulu, he was a Kurdish refugee. He had been placed in Hillingdon under what used to be the NAS scheme, the Home Office scheme, and he hadn't had 10 years residency either. They brought their cases under the Equality Act. Race, the protected characteristic of race, includes nationality and ethnic origin, and that brought them both under race. Possibly refugee status might be other status, but it didn't matter because Mr. Gulu had race. The residence requirement clearly put non-UK nationals at a disadvantage when compared with UK nationals, and the same applied to travellers. So there was discrimination, and Hillingdon simply had not considered it. And so the burden of proof shifting to them, they could not show that it was a proportionate response and a legitimate aim, and therefore it was unlawful. And then we come to the Supreme Court, Zed and Hackney, which is unusual on its facts, and it's also unusual because I said there was one case on direct discrimination, and this is it. Miss Z was a Hackney resident who needed a transfer. She was the single parent of 4 children, two of whom had severe disabilities, and they needed a 4-bedroom property. And she went on to Hackney's allocation scheme. Agudas Israel Housing Association is a charitable housing association who own properties in Hackney, and whose charitable aims were to let those properties primarily to members of the Orthodox Jewish community. And Ms. Z was not a member of the Orthodox Jewish community, and therefore prima facie that's direct discrimination. I should have said that you got onto the housing association list through Hackney nominations, but obviously Hackney were only nominating those who were Orthodox Jewish onto the housing association list. So you think, well, direct discrimination, and you also think direct discrimination is what it is. There is no justification in it. There is no test of proportionality or legitimate aim. But there are 2 important provisions in the Equality Act. The first provides for positive discrimination at section 158, where a person, which in this case would be the Housing Association and Hackney, reasonably thinks that persons who share protected characteristics suffer a disadvantage connected to that characteristic. Persons who share protected characteristics have needs that are different from the needs of persons who do not share it, or participation in activity by persons who share a protected characteristic is disproportionately low. This is what allowed the Labour Party to do all women shortlists because there were far more men than women who were Labour MPs. And so the Act does not prohibit P from taking any action which is a proportionate means of achieving the aim of enabling or encouraging persons who share that protected characteristic to overcome or minimise the disadvantage, meet the needs, or enable them to protect in that activity. So it's a form of positive discrimination. Section 193 applies to charities, and a charitable an association that's acting in pursuance of charitable purposes can be applied to people who share a protected characteristic and not to those who don't, if it's a proportionate means of achieving a legitimate aim or to prevent or compensate for a disadvantage linked to the protected characteristic. And if you think of the voluntary sector, there are Muslim women's groups, there are Chinese groups, there are all sorts of groups that deal with specific protected characteristics, and of course it's right that they should be there, and that's section 193 achieves that. So at all three levels in Z and Hackney, at the Administrative Court, then at the Court of Appeal, and then at the Supreme Court, the Administrative Court first of all came to various findings that the provision of accommodation solely to members of the Orthodox Jewish community was appropriate positive discrimination within section 158, and they did that on the basis of the statistics that show that members of the Orthodox Jewish community were more likely to be in poverty, overcrowded accommodation, they had a need to live within their community, they suffered anti-Semitism and racism, and they had profound problems obtaining private rented accommodation. So whilst there was apparently direct discrimination, it was the positive discrimination at section 158 amounted to a proportionate method of achieving a legitimate aim. That was aimed principally at the housing association, but Hackney's nomination policy effectively stood or fell on the basis of the housing association. So that's very interesting. I'm going to give you one more case on indirect discrimination. I'm then going to tell you about some slides, but I'm not going to go through them because Connor's telling me I have 5 minutes left. And this is Muir and Birmingham. And Birmingham have had a lot of litigation recently. Mrs. Muir was the mother of a disabled adult daughter. They were in a council accommodation. They needed to move to adapted properties. There was the allocations policy said that families with dependent children were given priority for houses. And in practice, they weren't just given priority, but if you did not have a dependent child in your household, then you couldn't get a house. You were skipped over. That was the operation by the officers. She was only entitled to bid for adapted properties. She was not entitled to bid for non-adaptive properties because of her daughter's disabilities. And all of those were houses. So every bid that she did, even when she came up bid number 1 at the top of the queue, she had the highest priority. She got skipped over in favour of a family with dependent children. And Birmingham had, so first of all, the comparator was with a family without a disabled member, and clearly there was unfavourable treatment of the families with a disabled member in it. The question is justification, whether it was a legitimate aim, and proportionality. Birmingham had to some extent looked at this when they had developed the policy, but they looked at it on the basis of, well, it's obvious that families with children should have priority for houses. They need open space, gardens, etc., etc. What nobody had done at a council level was balance the fact that if you gave that priority to families with dependent children, the knock-on effect that would apply to families with disabled adults who did not have dependent children. So although they had started to look at it, they had not done so properly. What is also important about NUR is that has confirmed for us that anything in relation to allocations, including where somebody is simply transferring from one existing property to another, is a public function and so it falls under Section 29 of the Equality Act, which means in Birmingham's case that they should have anticipated that there was a need for reasonable adjustments for families with disabled adults in them, and they had failed to do so. I have run out of time, which means that you're all going to be sent the slides, and in the slides are the public sector equality duty set out, the lengthy quote from the leading case of Bracken, which says what should happen with the public sector equality duty, and then the discussion of public sector equality duty in Ward and in Muir number 1, which both of which were similar to justification for indirect discrimination. If you've looked at it properly, a local council will probably survive. If they haven't looked at it at all, or if they haven't looked at it properly, then they're unlikely to do so. I've given you what guidance there is. It's limited. And what do you need if you are somebody who is looking to challenge whether or not there has been unlawful discrimination? You always need the allocation scheme. It's the point Tessa made. You ask for any reports that were put before council when they were adopting or amending the scheme. You need your client's individual documents on the file, and quite often freedom of information requests on the number of lettings, the characteristics of successful applicants, and so forth is also useful. I have gone on a little, Connor, but you'll be glad to hear that I'm stopping now, and I'm happy to deal with questions.
Thank you both, Liz and Tessa, for those brilliant presentations, and thank you for keeping us to time so assiduously. What that means is we do have 15 minutes left for questions. If you do want Liz just to pick up on some of the material she'd missed and at the end, because I've been chivvying her along, then please do ask. As I said at the beginning, questions in the Q&A rather than the chat, if you can find the Q&A function. We've already got a few in there, but I'll try and pick out the ones in the chat as well. I'm going to start by, if I can, trying to group them thematically, and I'm going to pick up where Liz has just left off with the topic of discrimination, with the question from Mark Pritchard, which is whether or not a local housing authority's justification for differential treatment, as in the cases of HA and C in Islington, can occur after the implementation and adoption of the policy.
The short answer to that is no, because it is about what they had in mind at the time of the policy. I'd have to take you through the cases. It's not unusual for a court to find that some broad statements at the time of adoption or amendment actually meant various things that council officers are then saying in evidence meant, when it's not clear at the time that that was what was before the council. But the short answer in law is that if you are saying that the allocation scheme is unlawful, then is discriminatory, then the justification must have been before the council when it made that policy decision. If you are saying that a decision taken under the allocation scheme is unlawful, then that's different, because it's the time of it can be the time of the decision, depending on the facts.
Thank you, Liz. I'd just add a gloss to that, if I can.
Please
I think it depends.
Yes.
I think it depends a little bit on how you are complaining about the discrimination. If you're complaining about it through the lens of the public sector equality duty, if you're saying that this is something that should have been considered before the policy was implemented, then the case law on the public sector equality duty is fairly clear to the effect that justification shouldn't be a rear guard action. That's the phrase in the case law. So like Liz says, it should have been considered at the time. But I think when you're actually dealing with substantive discrimination, the courts have shown a little bit of leeway for ex post facto justification. So the Supreme Court in the pensions case, Reed Brewster, said that ad hoc ex post facto justification will be taken into account. It may just be given a bit less weight. So like Liz says, it really should be at the time, but often local authorities and public bodies do get away with justifying their actions later. They may find that they are scrutinised more closely.
And it depends how it's put. In the Nuremberg Birmingham cases, you had this clear policy about families with dependent children having priority. And you then had two post facto twists to it. One was that in practice, officers were interpreting that as that was determinative, that somebody who didn't have a dependent child would not get a house, which was not what the policy said, but that was what the practice was. And then secondly, officers put forward witness statements which justified the policy. But that was ex post facto reasoning. So it attempts to rely on ex post facto reasoning can sometimes be accepted by the courts, but they mustn't be blatantly off-piste, as it were.
Thank you, Liz. So moving on to second question on the same theme, we've got a question from Julia Wheeler in the chat at 6:10 about justification. How do you evidence for local authorities justification for the discrimination? Do you simply rely on correspondence during the review process, the response to the pre-action letter, or do you look for underlying evidence, e.g. minutes of the meeting when the policy is determined?
Well, the starting point of that is that it's for the local authority the burden of proof is shifted to the local authority once there is unfavourable treatment. So it's for the local authority to do the evidence, but obviously you want, if you're acting for the applicant, you want to be thinking about it. And if it's, again, it's whether it's about whether you're challenging something in the policy or a specific decision under the policy. But if it's something in the policy, then certainly you want to be getting all the documents that were before the council when they adopted or amended the policy. And one of the things that, if you're acting for the applicant, you need to be thinking about is, well, you know, the council are going to use this for justification. You will usually find that they quote justification in their response to the pre-action protocol letter, and then you kind of need to weigh it up. But it's not for the applicant to evidence justification. It is the burden of proof, providing the applicant has shown unfavourable treatment, the burden of proof shifts.
Thank you, Liz. Okay, I'm going to move on to a couple of questions now which touch on legal aid. So the most recent question in the Q&A is from Sebastian Peaty. So what about legal help? Is legal help given for this type of case?
Tessa? Legal help's available for Part 6, isn't it?
Yes, yeah.
Yes.
Legal help's available. Well, we may have to crowdsource this one to avoid embarrassing ourselves, because let's face it, the legal aid questions are the ones that you deal with on a daily basis more than us. My recollection of Part 1, Schedule 1 of LASPO is that legal help is available for allocation cases where the person is homeless. But I'm hoping one of you more knowledgeable people in the audience will correct me if I'm wrong on that.
Right, but yeah, anyone who kind of deals with it, you often do chip in.
So that leads us into another question. The first question in the chat, another question from Julia Wheeler, is, do you know, and I suspect we do not know given our difficulties answering this question, do you know what evidence the legal aid agency require to show that the person is homeless? Is it sufficient for the fee earner to say that the person's homeless?
I have no idea what the legal aid agency require. No, I'm sorry. Solicitors, there are lots of solicitors on this call. There are 100 participants. Most of you are solicitors.
Okay,
well, the
good news is we seem to have passed the audience test on the last question, and we're getting some reassuring confirmations of our answer. My experience, and let's face it, LAA decision making varies wildly from case to case, is that it is enough for the fee earner to say that the person is homeless. But I'll be interested if others have different experiences. And that's it. Yeah, we're getting a few responses in the chat to that effect. Okay, a couple of questions now which relate to the relief duty insofar as it relates to the allocation of housing. So, question from Alexander Kaliadis, more of a Part 7 question, but relates to priority date under Part 6. Is there a merit in requesting a review of the relief duty on the basis that the duty should have been awarded several months earlier? The consequences of delay is that the client is deprived of main duty and will have a later priority date on the housing register. Liz or Tessa, what do you think of that?
I think yes. The review would be of the decision that you are homeless and you're eligible for assistance, and therefore, as of date X, the date of the letter, we owe you a relief duty. Whether or not Section 202(1)(b) gives you a right to request a review of a decision that a duty is owed or not owed, so not of the details, might be tricky. Tessa?
Yeah, I think that is tricky. I think I'm probably looking in the first instance as to whether you could review the allocation decision on the basis that if the relief duty was owed, then the client must be homeless, and therefore that doesn't require, and I'm possibly going to answer another question with this, that doesn't require a sort of specific Part 7 decision. It just requires the client to be homeless as defined within Part 7. And therefore, if they were homeless much earlier, then it should be dated from that earlier time.
I think that's right. I think it's better to deal with the allocation decision.
Thank you both. Okay, we're getting lots of useful qualifications to the legal aid questions. So in particular from Rebecca Bahar and Diane Astin, just pointing out that really whether you're going to get legal help is going to depend exactly on what the circumstances are and what legal aid contract you have. Because if your case, for example, has a discrimination element, then legal help may well be available. Likewise, if you are threatening a JR and have a public law contract, then you may have legal help by that route. So the specific provision of LASPO that provides for Part 6 cases where somebody is homeless is not the only route to legal aid. I'm now going to take the questions. Oh, sorry, there was one more question on the relief duty, which Liz, I think you were going to answer, which is going back to the beginning of Tessa's slides. Why is the prevention duty included as a reasonable preference category, or a subsidiary of reasonable preference category, but the relief duty is not owed?
It's a very good question. I wonder, can we, Tessa, if I stop sharing, can we get your reasonable preference slide back up, or is that too complicated?
It might be a little complicated.
All right, okay, not to worry. Julia, there are two answers to that. The first is that of course, the Homeless Reduction Act 2017 brought in the concept of relief duty and amended the prevention duty to make it much more effective, much stronger. But the Homelessness Reduction Act only amended Part 7 of the Housing Act 1996 and did not amend Part 6. So that's the practical answer. But if you look at Section 166A, 3A and B, then obviously we have the prevention duty within B, but there is no doubt that anyone who is owed the relief duty must fall within A because they are homeless. A local authority has already decided that they are homeless. It says so in the letter saying we owe you the relief duty. They are either not in accommodation at all, or in the sofa surfing type of accommodation that means that they are homeless legally, or they might be in Section 188 accommodation, and there is long-standing authority that you remain homeless if you are in Section 188 accommodation. So if that point were ever raised about somebody who had the relief duty owing to them and nothing else, then the very strong answer must be that they fall within A.
Thank you. Okay, we've now had so many brilliant questions. I'm going to abandon my attempts to group them thematically because I'm just not going to succeed, but I'm going to take Rachel Lovell's question from Lewisham Law Centre next, just because I think it looks particularly interesting. And this is a question about people with composite needs and what priority they should be given under the allocation scheme. So Rachel asking, is it correct that if you have multiple reasonable preference categories that apply to you, for example, you've got medical reasons, and you're in overcrowded accommodation, but you don't get any extra preference for having more than one, that is still giving reasonable preference and is lawful. Is there any chance for an Article 14 Slemenos type argument?
Tessa, do you want to do first bit, and I'll try the second bit.
Yeah, so basically, yes, it is correct that you don't have to be given cumulative preference. You don't have to be given more priority because you fall into more than one reasonable preference category over somebody who only falls into one of the categories. And that is in the code, and I think was also the decision in Armad and Newham in 2010.
Yeah.
So yes, that is correct.
Yes, and that's what, I mean, the code reflects the House of Lords decision in Armad and Newham. Would there be an Article 14 argument? Don't know, frankly. Hasn't been tested in the court. Would need a bit of thought. The Flemos type argument is in relation to understanding that people with different needs have to be treated differently rather than treating everybody the same. In other words, you're trying to achieve equality of outcome, not as it were equality of opportunity. And so the argument would be treating me with my several needs on the same basis as somebody with just one need is not recognizing my different forms of other status. Could try it, don't know. Tessa, do you agree with don't know?
Yeah, I think that's right. I think it's a really interesting point.
Yes.
I mean, I can see the basis that you're treating different cases alike, and that's obviously for not discrimination. Obviously, you do have Armad saying that you can do that, but that wasn't the discrimination point that was run there. So it's a different question. So I think, yeah, I think maybe it's one to be taken.
Yeah, I have no memory of the Equality Act featuring in Armad, I have to say. I mean, I could be corrected if I'm wrong, but I don't remember that being an issue.
You're completely right, Liz. And Lord Neuberger in his speech in Armad specifically sort of carved out a sort of a category including discrimination as being situations where different rules would apply. You're not just approaching it on a Wednesbury basis. If I could either offer a slightly more pessimistic view on the question, that the latest word on discrimination in the social welfare context is the Supreme Court decision, I think in SC, where really the Supreme Court poured water on any kind of discrimination challenge in this kind of arena. So not only is a very low threshold going to be applied, this court's not going to scrutinize it particularly quite carefully. It's only going to ask whether it's manifestly without reasonable foundation, which is a pretty easy test for a local authority or public body to justify. But also, I mean, the Supreme Court in that case have made it clear that in any welfare benefits, social welfare type situation, rules are always going to be discriminatory. That is the point of the rules. They are saying that one group gets something and another group doesn't. So although that is not a carte blanche for any kind of discrimination, you know, once you take that into account, it's always going to be difficult to succeed on a discrimination challenge in this context. So basically, I think if a local authority could offer any kind of justification for not awarding composite priority, any sensible justification, then I think it would be a hard challenge. Okay. Another question from Mark Pritchard. Now, folks, I am conscious that we are at time now. I can see there are still quite a lot of people here, so we will continue. I hope that's okay with Liz and Tessa, and try and answer a few more questions. But obviously, if you feel the need to move on and get on with your evening, then please do. But with that caveat, question from Mark Pritchard: am I correct in thinking that if a local housing authority insists on a housing registered applicant having an active homeless application with themselves in order to be afforded priority on their Part 6 scheme, along the lines of you won't get homeless points if you're not a Part 7 applicant, this is most likely unlawful?
Well, yes. And I mean, Tessa will remember better than me, but I am pretty sure that the code of guidance on section 166A 3A, in other words, reasonable preference for those who are homeless, it says that you have to be homeless within the Part 7 definition, i.e. extending the definition of homelessness out. You can't just restrict it to rough sleepers. But it's yes, you can be homeless anywhere in the country. I mean, you might not be picked up because of other qualifications, but you can be homeless, and you don't. And the very point of having the difference between A and B is that B is supposed to pick up those people who are statutorily homeless and who are owed a duty. So A must be the other types of homeless people.
Yeah, I think the Welsh code addresses it directly and says that you don't have to have made an application. I don't think that the English statutory guidance does, but I mean, it's the same. That just can't be lawful.
Thank you both. Okay, we've got 2 more questions in the Q&A now. So the first relates to choice-based lettings versus direct offers as a ways for administering the allocation of social housing. So when a local housing authority has a choice-based letting scheme, but their scheme also allows for direct offers, where a direct offers policy listing the emergency circumstances where a direct offer may be considered. What is the maximum? What do you think is the maximum percentage of properties that can be allocated through direct offers before they dominate the choice-based letting scheme?
So
you go first, Tessa.
My sort of provisional view on that would be there isn't a maximum, because a local authority doesn't have to have a choice-based letting scheme at all. It just has to have a statement on its position vis-a-vis choice-based letting. So it could have a scheme which made only direct offers. I've seen that kind of question arise in relation to reasonable preference. So there's an argument that setting aside a quota of properties undermines reasonable preference and means that the scheme as a whole doesn't give reasonable preference. But unless it was inconsistent with the wording of the scheme, I can't immediately think of anything that would say that there would be any maximum, or even that they couldn't make all of their allocations via direct offers.
I agree.
Thank you. Okay, and penultimate question, because we've had a further comment. Is it lawful for a local housing authority following a challenge to them making a decision other than in accordance with the policy to simply update their policy in order to justify remaking that same decision?
Well, it depends how they did it. I mean, it's sort of what happened in Ward, because Ward was initially about the residence requirement being qualification, and then during the course of the proceedings, Hillingdon amended the scheme so that they put the residency requirement into preference, priority, and band D. You clearly could not do that out of bad faith. That would be a fundamental error of public law. But it is not bad practice if a local authority recognises that they have done that an aspect of their scheme might be unlawful, and they change the aspect of that scheme. I'm not entirely sure that's what the question said, but if they did that, that's fine.
Yeah, I'd just add to that the possibility of a legitimate expectation. If there's a policy that says an applicant in this situation will be treated in this way, and your client bits that and wants to be treated in that way, and they change their minds in order to avoid treating them in that way, I mean, I think that would probably fall under bad faith, but may also be a breach of a legitimate expectation. But an allocation scheme should ideally at least say how it will deal with applications made before the date of any changes, but they don't always, it has to be said.
Legitimate expectation in allocation is tricky. You need to keep Alancy and Newham in your mind.
Yes.
Okay, and we've had a further comment on the availability of legal help from Rebecca again. So I'm just going to I'm not sure if you, the audience, can see the Q&A. So just in case, I'm just going to post what she said in the chat, because there's a very helpful link there together with references. Okay, that covers the questions in the Q&A. We did have a few others in the chat, but I'm afraid I've lost them amid the helpful legal aid responses. So I think as people are now starting to move on, we're going to bring things to a close. So thank you all very much for coming and for staying with us, particularly beyond the allocated time, and for having such brilliant questions. It's really great to have you involved. And thank you to our speakers, Liz and Tessa, for such brilliant, informative contributions.
Thanks, everyone.
Thank you.